the next case, which is Hall versus Citizens Property Insurance Company. I should have Mr. Nation. I see you. Mr. Nation, good morning.
Good morning, Your Honor.
Excellent.
That is not my opponent.
I agree. I was about to say, we're waiting for Ms. Maureen Piercy, and it looks like Mr. Parks' camera came on. So there we go, Ms. Piercy. Excellent. All right. And just good morning, Ms. Piercy. All right, everyone. I think you all know 20 minutes aside. Mr. Nation, whenever you're ready, sir, and how much time do you wish to reserve for rebuttal?
5 minutes, Your Honor. Thank you.
Very good. And with that, the panel is ready, sir.
Yes. Good morning, everybody. And this is a first-party case. In a typical first-party case, our verdict form is going to have 3 questions on it. First would be, did we prove damage during the policy period? Second is, can the insurance company prove it's excluded? Third is, what is the amount of damages that we prove, dollar amount? In this case, question 1 ended up being stipulated to. And as to question 3, the amount to cost to tear out was never in dispute. That cost was not rebutted. We put in the cost. They didn't have an opposing cost. And so the entire case was focused on one issue. And that is, did the cast iron pipes underneath the whole house have a hole in them? If they did, their plumber, Citizens plumber, said it best when he said, if there is a hole in the drain line, then the entire drain line would need to be replaced because it would have the same integrity. So that was the issue in this case. The 4 issues I raised on appeal bear directly on that one issue. The first one is, what was in the bathtub? And Mrs. Hall testified that there was sand in the bathtub. That was important because if there's sand in the bathtub, there's a hole in the line. My master plumber, licensed master plumber, testified. I showed him the picture and I asked him, what is that in that tub? Citizens objected. And I came back and said, do you know what that is in the tub? He said yes. And then the court sustained an objection, not allowing him to say that it was sand in the tub.
Well, Ms. Hall had already testified that there was sand in the bathtub, isn't that right?
Yes, Your Honor. She had a non-professional, but she had testified to that. Ultimately, their expert testified you can't know, he was allowed to testify, you can't know what's in the tub if you don't touch it. A juror asked that engineer, Citizens engineer, a question about that issue. And that's what brought that up. So we know it's an important issue. My expert, who's a plumber, needed to be able to say, looking at that, based on my experience, that is sand in the tub. And that proves there is a hole in this line. And so it was an issue important for my expert witness, clearly an issue that's important for the jury asking a question about it. Their expert got to testify about it, that you can't tell. And then it was a big issue in closing. That whether or not there's a hole in the line is the issue in the case. But that's only one of the grounds. Yes, Your Honor.
What was the judge's reasoning for excluding that?
That he had not been present when the picture was taken. That's it.
Were you able to, did the judge give you, and I have the transcript, and I want to hear from you, were you able to give him the opportunities to lay the proper foundation in order for him to testify to that?
Yeah. Yes, Your Honor. I had his background and experience in the record. I asked him if he knew what it was, and that's when he got shut down. And so obviously he didn't need to be there when the picture was taken. That's error, obviously. And as Citizens is the beneficiary of that error, they're going to have to show no reasonable possibility it could have contributed to this verdict. But obviously it's not the only error we're here about.
And when your client testified that, okay, she took the photograph, you're able to lay the foundation through her, that she's the one that took the photograph, and this is the photograph was an accurate depiction of what was taken at that time. Were you able to lay that foundation through her?
Yes, Your Honor, and that picture was stipulated into evidence.
All right. All right.
Mr. Nation, was the expert allowed, you're saying the expert was not allowed to rely upon Ms. Hall's testimony that it was sand?
I don't know that I asked that. I asked.
Well, see, that's the question. Yeah, that's the question I wanted to ask. Was the expert asked, or did the expert's opinion, was it based upon the facts that Ms. Hull had testified that it was sand? Because it would seem to me that an expert certainly is allowed to rely upon that information. And if that information got out, then then I don't see the harm here with that.
Yeah, yes, the expert himself was asked, looking at the picture, what is that? Do you know what that is? And he did know what that was. I don't recall if going through his direct, if I asked him, I want you to assume that she has said it's sand based on that.
Well, not just assume, she did say, she did testify it was sand.
She did.
Okay.
I don't know that question was asked. Thank you. I can't say one way or the other. All right, the next error I want to talk about is the belly in the line. I'll explain a little bit why that's important. It won't take long. The cast iron pipes underneath the house drain just by gravity. And so when they're installed, there's structural fill put in underneath the ground. It's compacted. The pipes are laid in there, structural fill put on top of that, the slab on top of that. And the pipes are angled down. If that structural fill becomes displaced, then the pipe either back pitches, so the sewage can't get out of the house, or it gets a belly in it. And what we did is put on evidence. We videotaped the inside of those lines. It looks like a big colonoscopy camera. And you snake through the lines. And our expert said there were holes in the line. It showed it. We did a hydrostatic test, which is you plug up the line, fill it with water. We'll talk about that in a moment, and just see if it leaks. And so both sides agreed that this had a belly or a back pitch in it, all of which goes to the structural integrity and whether or not there's a hole in this line. They were allowed to say, their expert plumber was allowed to say, that that was due to the original construction in 1959. Sheer speculation, no basis for it whatsoever. He had testified in his deposition that nobody cameraed it back then, and so he didn't know if that existed back then. Yet he was allowed to testify at trial in front of the jury over strenuous objection that that was there since the original construction.
And Mr. Nation, on this point, the court kind of hit a reset button and said, let's clean this up. And then you were allowed to cross. And so I'm trying to see, after that objection was made and after there was this effort to kind of clean this up, what was the court's ruling at that point?
Originally, the court sustained it and was going to strike it. And then
but after that point, because I'm looking at a preservation issue here and whether there was a definitive, because as you know, we need to have a definitive ruling from the trial court in order to assess whether there was error. So what was the ruling here by the court after the objection, after the sustained, and then after this effort to clean this all up?
She specifically said on the record that he's allowed to say that it was there. It's his opinion it was there from the beginning.
And was there an objection or a motion to strike at that point in time?
That was her ruling from my motion. He then testified to that, and I got up and said, "That's my objection. That is the objection right there."
And the ruling, and then the ruling on that point was
overruled. My objection was overruled.
And do you know what record site is that?
Let me see if I have it right here. It'll be in my facts section, but let me see. I have my cheat sheet here.
I don't want you to spend too much time on it. If you wanted to give me, if you find it later when you come back up for rebuttal, it's fine.
Yes. The next area is their plumber. I was going to cross-examine their plumber, and I want to put this in context. I gave my trial exhibits and my impeachment material to Citizens Council months before the deadline to do so. Gave it to them. Jury instructions were all determined long before trial. We go in, And I want to cross-examine, well, I told you about the videotape. So you go through the videotapes of the line. Those aren't something any of us typically look at. And so what the inside of that line is demonstrating has to be explained through expert testimony, like an MRI explaining what the MRI shows or an expert. What I wanted to do is cross-examine their plumber. I had a picture of a cast iron pipe that had a crack in it, and it is identical. If you look, and I have it in the brief, you put it side by side, and you look at the inside of the videotape, the screen grabs of what we have from inside the lines, it's identical. That plumber, excuse me, knew exactly what that was as soon as I showed him. He said it's a cast iron pipe, and he knew that it had a channel and a crack in it. And I wanted to be able to show him and cross-examine him and show him what we have in these videotapes is exactly what we have in this pipe. And I've made it clear it wasn't from this house. We knew that, and that wasn't going to be an issue. And the court said I couldn't use it, that he wasn't there. He doesn't know how old it is or if it's residential or commercial, none of which matters. None of which matters. And it's as if on this critical point, every time I had important evidence on that, shut down. And when they had evidence on it, we're allowed to speculate or use a test that they made up on site.
Let me go back, Mr. Nation, because, you know, for us to review whether or not it was error for the court to exclude it, you were trying to use it as a demonstrative aid. Is that correct?
In cross-examination, yes.
In cross-examination. And when we review that, any issues regarding whether or not the court will allow any demonstrative aid, we review for an abuse of discretion. Are you taking the position that in this case, no other, and you know the standard,
yes,
means no other judge in the whole state of Florida would have concluded the way this judge concluded? Just help me out as to why this is reversible.
Yeah, Your Honor, if it had been any one of these, I think they're pretty significant when any one of these bears on the precise issue. This one in particular, and I understand the standard, but the hurdle is low for using a demonstrative aid. Can it assist the jury? I don't see how any reasonable jurist could determine that this would not assist the jury. They're looking at a video and screen grabs of the inside of a cast iron pipe underground. They see things, we're saying those are cracks underneath the line. If we're right, we win. I have a demonstrative aid, a picture of a cast iron pipe with a crack in it, making it clear it's not from this house, but just as a demonstrative aid, just as if I was holding an anatomical model next to an MRI to give context to what we're seeing. I do not believe any reasonable jurist could keep that out in this case. And I hate saying that, but I do believe it to be true. I was very shocked that I could not use that, on top of the other things that we had going on here. Now I'll get to the last point, my fourth point, which is the test that they call the pressure test. I want to explain the test just so we make sure we understand. I explained that the pipes are underneath the house. What happens in a pressure test is you take the toilets off, you take the sinks off, and you have a ball that you stick in there and you pump it up with a bicycle tire pump. And you close off all the openings in the house except for one. So they're all closed off. So you're going to load the system with water to see if it leaks. I put in all the code regulations in our case to show that to do that test, you have to bring the water up to 5 feet above the lowest sink or toilet or whatever. 5 feet of head, that's what we're talking about, to put pressure on the line. Experts from both sides said the purpose of that pressure was to determine if you have leaks. Because if you don't do that, the leaks maybe have grease around them, they may have other sewage, whatever around them, and you can't tell if there's any leaks. Their expert went to this house with the purpose of doing that test. They didn't do it. They said you couldn't. We disagreed, we were able to do it. That's not the issue. He then made up a test at the house where you put no pressure on the system. Again, bearing specifically on this one issue that's really going to control the case. They put no pressure on it. Instead of 5 feet of pressure of water, when I say pressure, they put a clear plastic tube up, and it's 5 feet, and they fill it. And
Mr. Nation, the trial court's decision to allow this testimony and the review again is an abuse of discretion, correct?
Yes, it is.
Okay. And so this is the part of the transcript that there's a sidebar off the record. Is that right?
During lunch, what we did is we had argument during lunch, and then right after lunch, we were able to do the entire issue during lunch. So there's no inconvenience to the jury whatsoever.
Yeah, but the actual argument is off the record, and then a summary is made on the record.
That is correct.
Okay, I just want to make sure I'm on the right point. So I guess my question is, as I read the transcript, the trial court leads in after the argument is summarized and citizen says something to the effect, yeah, that's accurate. I can't remember the exact words. But then the trial court says, as an additional basis, it states that the trial court finds that the objection is late. And so I'm trying to understand, if we're looking at this as an abuse of discretion, how can we fully determine whether the trial court erred under this standard when we're only seeing a portion of the trial court's ruling?
And before you answer, Mr. Nation, just want to remind you, you're about to get into your rebuttal, okay?
Yes, Your Honor. That was the only reason. That neither side.
But I can't, but I know, see, we weren't there and you were there. And so as I'm reading the transcript, it says I think it says an additional basis. So, you know, I don't know what to do with that other than to assume there might've been another ruling.
The deposition, we put in the deposition, we had our testimony from our expert and showing how the test is to be done. We should put in their plumber's deposition to show that they didn't do a code compliant, but that was consistent with ultimately with his trial testimony. So you have all the testimony there. There wasn't an additional basis. As she leads in, she says, and just so the basis of, and then does say an additional basis.
Right.
There isn't an additional basis. Neither side had it, and that was the basis. There isn't one.
Okay.
The only basis is length. And I would remind the court, I don't look for a perfect trial. I don't know that I can do the perfect trial, but these points bearing on this specific issue. And it was other than that, pretty clean trial. This deserves a retrial just to get this stuff before the jury for a fair trial. Thank you all.
Very good. And Mr. Nation, I'll go ahead and give you 4 minutes because I know that you were asked that question right into it. So I'll give you 4 minutes for rebuttal, sir. Very good. And then, excellent. Ms. Piercy, if you could unmute your microphone, ma'am, we are ready for your response.
Good morning, Maureen Piercy on behalf of the Appellee Citizens Property Insurance Corporation. I would like to start out, if we could, with the Daubert issue because it was just addressed. The court very clearly said, and it's on the transcript, the volume 2 of the record, page 363, an additional basis of my denial is a very late motion in limine as opposed to any under any prior court order. And we brought this out in our brief. The orders were very clear that all Daubert motions had to be filed and heard before the pretrial conference. That didn't happen here. And then the order has something about it. There's exceptional circumstances that it would be considered. It wasn't done at all. So at that point in time, the court had the discretion to deny it. And remember, we're in the middle of a trial. This was brought up on a lunch break. We don't even have a record of what really was discussed at that break other than what was represented to the court reporter. So at that point, the court was fully within its power to deny the motion on that basis alone.
Ms. Piercy, If I am understanding, I just want to make sure I'm understanding your argument on this point. To paraphrase, your position is that there are two bases to affirm this ruling. One, the merits basis that we can't really see from this record because we don't have one. The trial judge didn't abuse discretion. And your other argument is the trial judge didn't abuse her discretion by standing on the timing provisions of the case management order. So you basically are asking us to look at two alternate bases for the trial judge's proper exercise of her discretion to affirm. Am I paraphrasing your argument correctly?
That is accurate. And I also, in our brief, we did address what was discussed about the test that was done by our master plumber and our engineer. The engineer was present and the plumber did it. And they explained a couple things. First of all, the building code does not require this test to find out if there's a leak in a system. The building code is set up to deal with when somebody's getting a permit. So new construction, they're putting in new pipes, they're permitting, they want to make sure the new pipes that were put in don't have holes or are properly sealed. That's when the test requires it. And our engineer testified to that. It's not required. They go out there, they find a damaged flange in the guest bathroom and say, if we do that test under the building code, we could potentially flood their bathroom with raw sewage. So they explained why they did the test they did and what it was based on and what it would show. That evidence was offered. But again, I don't think the court ever needs to get there because of the whole timing issue. And we did cite Booker and Gutierrez on that issue, and I think they both are pretty clear. And if you look at the cases that the other side cited, every single one of their cases where they get into the whole gatekeeper function, there were motions filed. The argument was timely raised. So that's a pretty important distinction in my mind. I'd like to, unless the court has anything else on the Daubert issue, I'd like to move on to the other issues that were raised. With regard to the sand in the tub, Kathy Hull testified live, and she testified she took the photo came in evidence that she saw sand in the tub. We have direct testimony of what that photo showed.
But
so
Ms. Piercy, so what is the harm then? He has his expert and he's like, look, here's his photograph. And we all know, sometimes if the actual plaintiff testifies to something, I mean, it becomes a question of credibility for the jury. And sometimes you have an expert coming and say, hey, this is what it is, especially if it deals right into the heart of their case that, hey, this sand could bring proof of the fact that there's a hole. Why isn't that a problem?
I don't think it is because first, it's an abuse of discretion standard. And as you had pointed out, Your Honor, they would have to show no other judge would exclude it. And that's not the case. If you look at the testimony now, again, their expert, Mr. Fetzner, went in and he talks about where he found sand all over those pipes. This is his testimony. This is what the jury heard. I went in, I found all of this. I found channeling, I found holes. We have videos of this that they took in March of 2019. And that goes right to the issue. I found sand here, I found sand there, I found, so I don't think, I think the real question is, what was the harm in him not testifying to what was or was not in that photo? And here's what I think the harm is. Ms. Hull, part of her deposition was read to the jury. And in her deposition, she didn't testify to sand in that tub. She testified to water. Nasty water, as she called it, liquid. She comes live at trial and she says it's sand. So if we let the expert come in and say, oh yeah, that's sand. I wasn't there, I didn't see it, but that's sand. That's bolstering where she has conflicting testimony. And again, I don't think you can find an abuse of discretion on that one issue, because whether or not there was sand in that tub, they had all of the testimony from their plumber who went out and his assistant, and also from Mr. Fetzner that talked about what they found when they videotaped it. I don't think that photograph is the be all and end all of this case when you look at the full jury trial. And it has to be considered in the context of the entire record. If you have nothing else on that, I'd like to move on to the issue with the belly and the swag in the pipe. No one disagrees.
Before you get to that, since we're talking about photographs, how about the demonstrative aid? Why Why isn't that a problem? Again, we all know that it's up to the judge to allow or not allow. It's an abuse of discretion. Why a simple demonstrative aid, especially if he was going to clarify to the jury, this is not a picture of the house. I'm just using that as an example. I just want to be able to show to the jury. They say sometimes, you know, a picture is worth 1,000 words. You could explain, but if you have a demonstrative, it's much easier. Why isn't that also another problem with the judge excluding it?
And for the same reason, again, we're looking at an abuse of discretion standard, as you recognize. Now, first of all, they could have tried to introduce it through their own expert or witnesses, and they didn't do that, which is interesting. Instead, they decided to try to introduce it through Citizens expert, who said he recognized it as cast iron. He did not know if it was if it was a commercial or a residential pipe. He didn't know if it had been under a house. Now, this, we know at the Hulls residence, the pipe, it's a residential property, and it was underneath the house. This could make a difference to how the pipe ended up in the condition it is in. Our expert discussed that, and Citizens objected on multiple grounds: foundation, relevance, foundation, prejudice, and that it would confuse the jury. So they've seen photos and they've seen multiple videos. I believe there were 3, it may have been more than 3 videos of these pipes. They've seen what these pipes look like. So to come in with some other pipe, quite frankly, I don't see how you reach an abuse of discretion on this issue in light of the rest of the testimony. And that issue alone, again, I don't think is what sways the case one way or the other, because there was all of this other evidence on the condition of the pipes under the Hulls residence. And there was plenty of testimony on both sides. I mean, again, this was a case about the experts, a battle of the experts, a classic example, and the jury made their decision. With respect to the belly and the swag, everyone agreed that there was a belly in this pipe. That wasn't in dispute. There was no dispute that there was a loss to the property during the policy period. So we have a stipulation by the parties, and that's in the record at 1554. And also when the court read the jury instructions, volume 2 at page 21, the parties agreed that the Hulls homes sustained direct physical damage caused by water during the applicable policy period. So whether or not, so we have that stipulation, and then our master plumber testified it didn't matter because it was holding water. And I believe Mr. Johnson may have testified to that also. When they decided the system was holding water, it didn't matter to them one way or the other if there was a belly or swag or how it got there. The only issue, and Mr. Nation started out with this, the only issue in this case was whether there were holes in those pipes and those pipes needed to be replaced. So while there were a couple statements from Mr. Rodriguez about construction, I don't think in the end, I think at best it's harmless error because it didn't go to the issue that the jury was deciding, which was, were there holes or not? And going to that issue of, really this was about, do we need to rip out the floors to get to these pipes and replace them? And our plumber had also testified that that didn't need to be done because they could have rerouted the pipes. So that's another issue where you're looking, when you're again looking at this whole record together, I don't see how you can find an abuse of discretion on any of these issues. The jury was given all of the information they needed from both sides, and we disagreed, absolutely. And the jury did exactly what they were supposed to do. They considered that evidence, they listened to everything, they watched those videos, and they made a decision. And unless the court has any other questions for me, we would ask that the court affirm on all grounds.
All right, thank you, Ms. Piercy. And I'm gonna ask you please to mute your microphone. All right, Mr. Nation, you have your 4 minutes, sir, for rebuttals.
Yes, Your Honors, thank you. The discussion, let me get my notes, regarding the construction issue took place between pages 386 and 399. The court said she's going to allow them to ask the question. They asked it on page 399. I renewed my objection. And at that point, the court said, I told her, that's my objection. And the court said, noted, and proceeded. We had already argued it. On cross, I crossed him on his deposition testimony where he said he didn't know. So I'm putting that in context. Addressing counsel's arguments about the code itself, the importance of the code is it sets up the test to determine how do you perform the test to see if the system is leaking. Doesn't matter if it's new, both sides experts agree. Doesn't matter if it's a new system or an existing system, the test would be the same and the purpose is simple. You plug up all the holes except one, you fill it with water, give it 5 feet of head pressure to see if there are any holes in the system. And we did that test. They didn't do that test. And there's no basis whatsoever for that test according to their own testimony. You have to put pressure on it in order to do a valid test. Using that photograph in cross, I could either use it in direct or I could use it in cross. I gave it to them long before trial. My choice was to use it in cross. It never occurred to me that I wouldn't be able to use a demonstrative that clearly would assist the jury in seeing what the inside of these pipes, what we were looking at. And that was, I was precluded from doing that. That issue in and of itself could have easily swayed this jury. They saw the videos. It's like seeing an MRI. If you see it next to an anatomical model, it really puts it into context. That issue in this case was huge. As to whether or not it was a late Daubert challenge, again, I wish it had been done perfectly. To put it into context, the deposition, the test itself took place after those trial orders were entered, shortly before trial. We didn't get it until after that, and we took their depositions right before trial. And at that time, they talked about the test that they had performed just before trial. And it did not at all interfere with the trial itself. And in some ways, it put it into context. Again, this is not a situation where if we did it before trial, they could have fixed it. They said they could not do the test. So it's not tactically a ploy. But the judge then was given the opportunity to see our testimony, hear what the test should be, has in front of the court the code sections that say how it's to be done, and then sees how they did it. And it was not an actual test. And yet they called it a pressure test throughout their testimony. All right, unless there are questions, I don't have anything else.
Very good, sir. Thank you.
Thank you, Your Honors. Thank you,
Thank you, Mr. Nation. Thank you, Ms. Piercy. I'm going to ask you now to please exit, and then we'll be calling, actually, we'll just take a moment because we're going to have a panel